In 2023, in LaPorte, Texas, two workers working at a cold storage facility were unloading frozen food from a freezer rail car. One of the pallets that they were unloading fell. One worker was knocked out. The other worker was paralyzed by that accident. The employer, Americold, self-reported to OSHA the accident, and OSHA conducted an investigation and issued a citation under the General Duty Clause. In today's edition of the OSHA 3030, we're going to discuss the administrative law judge's decision and its significance to the employer community. I'm Manesh Rath, and this is the OSHA 3030. Well, welcome everyone to the May 2026 edition of the OSHA 3030. As I said, I'm Manesh Rath, and I'm an attorney at the law firm Keller and Heckman here in Washington, D.C. I'm very fortunate because I'm joined today by my good friend and colleague, Ben Idzik. Ben, welcome to the OSHA 3030.
Thank you, Manesh. Always a pleasure to be on.
Well, Ben, it's our pleasure to have you here, and I think we've got a really important case. This is the case of Secretary versus Americold Logistics. Why don't we talk about what we're going to talk about today?
Yeah, let's do it. So we'll begin with the facts of the case. We'll discuss the background, give you a sense of Americold, what they do, of the facility that this incident took place. We'll also discuss how the process of unloading the boxes that you mentioned in your intro generally takes place, as I think it's important for the setup of this case. And then we'll discuss the incident that ultimately took place in this case.
Right. And as we said, OSHA issued a citation alleging a violation of the General Duty Clause. We'll talk about the elements of what OSHA has to establish, in particular when citing an employer under the General Duty Clause, as opposed to when they issue citations under a standard. And then we'll talk about what OSHA's arguments were in prosecuting that citation.
Yep. And then in response, we'll figure out what Americold's defenses were of how they argued against what OSHA put forth in the citation. And we will then discuss what the judge thought about the arguments that were made by both sides.
Finally, we'll wrap up, as we always do, with what I think is the most important part of our program, the practical takeaway items for you in the OSHA 3030 community. We're going to talk about what employers should do in light of what we've learned from the Americold Logistics case. So with that, let's get cracking. The facts of the Americold Logistics case are really important to how the judge came down. So why don't we spend a little bit of time on that first?
Yeah, let's do it. So like you mentioned, Americold, they run cold storage warehouses, one of which is located in LaPorte, Texas. Now, these warehouses, what they do is they receive, store, and then ship to the folks at the end of the product supply chain, products that come into the facilities. So they typically come in either by rail car or by truck.
Right. They're essentially a middleman in a very complex supply chain. They receive frozen product from manufacturers or processors, and they send it on to distributors. But in the between, they are unloading it from rails or trucks, storing it, and then shipping it and to the distributor at the next step in the supply chain. And even by the judge's account, this is a very complex supply chain that they participate in as a critical link. And Americold in particular is a very large and sophisticated participant in that sector.
Yeah, absolutely. And like you mentioned, Manish, the incident that took place in this case happened on a rail car. So just to paint a picture of how these rail cars look, the products that are placed inside are either placed in boxes that are stacked from the floor up, or they're placed in pallets that are shrink wrapped, and the pallets contain boxes that are placed into the rail cars.
Critically, nobody at Americold knows when a rail car comes in on each and every rail car, which of the two methods the shipper has used. Sometimes they have enough advance notice as to how the product was stacked. Other times the folks at Americold only learn while the rail car is on its way or when it first arrives at Americold's site. And so this is a really critical point because the ability to prepare for a rail car by a specific method of loading is something that they have to do in real time and not something that they can prepare in advance for in each and every case.
Right. The first step in that process is a assessment that takes place of the cars to be unloaded. So when the cars come in, Americold employees will go around and determine what exactly is being stored in these cars and how to go about unloading them.
That's right. And that's an involved process, part of which involves attention to food safety, as part of it involves attention to worker safety, and then as well the logistics of how this task is going to be performed. Uh, the first thing they do is they evaluate the temperature in the car to make sure that the product has maintained its frozen state. And if it hasn't, then they know to return the product to the shipper. Uh, in addition, they're assessing how the product was stored, whether it was palletized and shrink wrapped, or whether it was stacked on the floor, and whether or not the stacks are in safe condition, whether they are still stacked and not shifted. And that assessment happens when the rail car arrives by a supervisor. The next step is a series of meetings to transmit information to the workers on those, at least those three features: the food safety, the logistics of how the task should be performed, and then how the task should be performed safely. What are the hazards that have been observed and how the task should be performed in order to safely work around those hazards. So there's three such meetings.
Right. The first meeting is a meeting between pre-shift, between the supervisors that are supervising the particular shift. Then there's also a general tailgate meeting for the whole second shift. And there's also a supervisor-led meeting between the rail crew itself, where the supervisor discusses what to expect and how to handle each unloading operation in the rail cars that are there for
Right.
unloading.
And a reminder of safety operating procedures for what they've observed for that particular car. So that is, I think, been intensive communication of safety issues. That is a part of the ongoing back and forth between the team and supervisors to the team of what hazards are being spotted and what safety practices to employ.
Right. And I think you mentioned this, Manish. What's important to note here is that this is a sophisticated process. The supervisors, they go through not just what is going to be expected to be unloaded, but also they go through standard operating procedures, and they stress and they highlight to workers what the hazards are to be expected from the unloading process. And I think that's important as we see what the judge found in this decision.
So the next step is that the rail car door, this all takes place, by the way, only with the second shift crew. So the second shift, after these meetings, they begin their work. It starts by opening the rail car doors. The safe practice at Americold that's employed is to do this as a two-person operation. That is obviously more expensive and more labor intensive, but it is safer. And Americold uses a two-person process for opening the rail car doors so that they could be moved in a manner where the worker is out of the way of any product that might fall out of the opening doors, as opposed to one person opening the doors and being right in the pathway of any falling product. So then a forklift operator moves by forklift a dock plate, which bridges the dock to the loading dock to the rail car. It's on that dock plate that all product will move out of the rail car and safely onto the dock.
Mhm.
And I think that step it takes place while the unloading staff is waiting so
Right.
that it can be done, and then they begin their unloading.
Right. So once those two elements are in place, then a supervisor comes around with the car opened and exposed and conducts an assessment of the state of the load that's in there. And the point here is to determine whether any shifting took place during transit to the point that it would be hazardous during the unloading process.
Right, and thereby whether the unloading plan that they had created and communicated would need to be adjusted.
Right. Because typically, if the car just contained boxes that were floor stacks, each box would have to be manually moved by the workers. But if they're palletized, then you can get a forklift in there to make the process easier. So there was, like you mentioned, an adjustment that takes place depending on the load looks.
So this is the typical process. I should also point out, Ben, as you know, the workers underwent significant training before they're ready for shift two. Their orientation training is multi-hours. Then they are assigned to a senior worker to shadow them, to see how to do the job safely and to spot hazards. And then there are constant walkthroughs by supervisors to monitor specifically for the purpose of monitoring whether the employee is doing his work as trained. So this is the standard procedure. Then on in March of 2023, this incident happens.
Right. So the incident took place while the folks were unloading a box of or a car that was filled with boxes of frozen chicken feet. These boxes in this particular case were palletized, and there were airbags that were placed in between the pallets by the shipper that provided a cushion. That this is referred to as dunnage, is a term of art in the industry. And the point is to prevent the palletized boxes from shifting to the point of them being leaned during transit. Um, so the first, like we discussed, the car was inspected and it was approved by the supervisor for unloading to begin as planned in this particular incident.
Right. Two employees, one by the initials MR and the other who's unnamed or redacted. They were in the process of unloading a particular pallet. I should point out these pallets, if if the product comes in palletized, then the pallets, if they can be safely unloaded by forklift, are done by forklift.
Mhm.
And if a palletized product has, for any reason, the load inside the pallet has shifted within the shrink wrapped pallet, then there's a safe process by which boxes are unloaded one at a time from the top down, and the shrink wrap is only released from the top enough to remove a box and then remove another one. And they use a cage on the forklift for workers to operate from until they work their way all the way down. In the event that they believe that any further unwrapping of the shrink wrap, cutting of the shrink wrap would result in a release of the load, then they use a controlled tumble down of the boxes inside that pallet
Mhm.
so that workers are safely out of the path of exit of those boxes from the shrink wrapped pallet.
Mhm.
This is important to note. Boxes coming in at commercial sizing might have been as much as 40 pounds per box, and there might have been 20 to 40 boxes per pallet.
Mhm.
So when these boxes tumbled down on MR and his coworker, the tragedy that ensued, which is heartbreaking, is understandable when understanding the weight, the potential weight of these pallets could be as much as 800 or even 1,600 pounds per pallet, maybe twice that, even maybe 2,400 pounds or more. That is theoretically possible without knowing the particulars of this case. So when two boxes are stacked up, and let us say each of them weighs, two pallets are stacked up, and each of them weighs maybe 1,600 pounds. Now you don't double that, but if they're toppling, what you have really are two 16-pound forces coming at different vectors, which could create a shearing kind of energy, and at each one of which is at 1,600 pounds, and that could conceivably, I think very easy to conceive, could result in the paralysis injury that we saw in this case. So just an incredibly unfortunate accident that happened on this day as they were
Yeah.
unloading their boxes.
Yeah.
Uh,
As
Americold immediately performed a incident investigation.
Yeah, they performed an incident investigation. They also reported, Manesh, like you mentioned, the incident after MR was hospitalized, and that prompted, of course, the OSHA to conduct an on-site investigation.
Right. Recollect, folks in the OSHA 3030 community, that in addition to recording in the Form 300 injury and illness record-keeping log any incidents, an employer must also self-report to OSHA immediately, promptly, any instance of a hospitalization. This also includes inoculations or amputations of any degree, and those have to be reported within 24 hours, and it has to be reported within 8 hours if there's a fatality. So often overlooked by employers or unknown to employers. I want to make sure you know about that. Americold did the right thing, self-reported. OSHA comes out and conducts an investigation.
Right. And they, like you mentioned, they issued a citation under the general duty clause, and the citation specified that the employees who were manually unloaded boxes of frozen poultry adjacent to pallets with leaning boxes were exposed to struck by hazard. So that was the basis of the citation that was issued.
Right. So OSHA comes out, issues this general duty clause violation. Americold contested the citation, and now it is a case before the Occupational Safety and Health Review Commission, independent adjudicatory agency. And now OSHA has to establish the prima facie elements of its general duty clause alleged violation. Those being that they have to establish that there was a condition that exposed workers to a hazard. OSHA has to establish that the hazard was recognized by the employer or generally recognizable by the industry, or through reasonable due diligence could have been spotted. They have to establish that the hazard is of a type that it could have caused or was likely to have caused death or serious harm, and that there was a feasible means for abatement of the hazard. And that last element is going to be a centerpiece of the judge's inquiry here.
Yeah, absolutely. So when we look at OSHA's arguments in this case, what OSHA said in its citation and in subsequent arguments before the ALJ is that Americold exposed its employees to struck-by hazards by requiring them to work near pallets with leaning boxes. That satisfied the exposure element of the citation, and they provided examples of how Americold was not providing specific protection to employees who were working in this situation. They said that the policy that Americold had in place was too general. They just required folks to notify their supervisors. They said that the policy did not provide guidance on how to unload by hand. They said that it was unclear whether and when to use a cage. So essentially, Americold was relying too heavily on vague and unhelpful prospects that did not provide actual guidance to employees.
That was OSHA's argument. And when asked what Americold could have done differently in its process, in its standard operating procedures for handling product safely, the compliance officer said, well, they could have had a better procedure. They could have had more clarity with what the employer should have told the employee to do in situations where product had fallen over or tilted, was leaning. And finally, they said that the compliance officer said that there should have been some kind of device to restrain the product from falling over.
Mhm.
Of course, once you remove that device for the purpose of unloading the product, you still have the same problem that you have to deal with shifted or leaning product. So that stored energy of leaning product is not solved permanently with restraints or devices.
Yeah.
But more to the point, the compliance officer didn't identify any such device. He simply said that they should have had some kind of device to hold the product from shifting.
Yeah, and that's certainly something that the ALJ and then Americold and its defense have brought up. There was also a point that I think OSHA raised that was interesting, and they relied on employer testimony that stated that Americold employees would have to work frequently around shifted loads, and there were complaints about this. But that's something that I think we'll see how it unfolds with Americold's point of view.
All right. So when an Americold has an opportunity to present its argument, and recollect, it doesn't have to present evidence exonerating itself of the allegation of a violation. The agency is responsible for carrying the ultimate burden to establish its case as the plaintiff or the complainant in this case. And so Americold can theoretically prevail simply by pointing out the elements of that are necessary to prove a violation that OSHA has failed to establish. Here, Americold established its standard operating procedure, the process that we described for how to handle products safely. And it pointed out that the employees were trained how to do this safely and that they were monitored on how to do it safely. And in this particular case, everyone was doing their work according to their training. More to the point, the employees were empowered if they believed that a load was unsafe or that it was safe when it arrived and it shifted, or for any reason circumstances had changed, that they were empowered to notify a supervisor. They were instructed, actually, not just empowered, but instructed to notify a supervisor and to have the supervisor conduct an inspection. That is very different from what OSHA had alleged, which was a complaint that employees were given vague instructions and were told to keep working if they until directly ordered to stop working if they believed the circumstances were unsafe. And that was not a finding that the judge arrived at,
No.
despite OSHA having made that allegation. We can talk about the judge's finding in a moment, but I think it's important to understand the essence of Americold's arguments were founded on very detailed explanations of its safe operating procedure that we've already gone over and its training that we've already gone over and what the employer or employee supervisor communication systems were for a typical day of unloading.
Mhm. And I think it's interesting and important to bring up to Americold's argument is that what Americold was saying is that there was actually no hazard that employees face in this particular situation. The boxes were not leaning during the unloading process. That was confirmed by the initial.
Particularly the two pallets that fell did not have leaning pallets.
Right. And that was confirmed. And the boxes that did shift during transit did not necessarily pose a hazard to employees. And that goes to your point, Manish, with respect to how important the process that Americold had in place for determining whether or not a shifted box was hazardous. They did think about that.
Right. We're talking to repeat the boxes may have shifted within the shrink wrapped pallet, but were not leaning and were assessed to be not hazardous, which is very distinct from the allegation that OSHA raised that the pallets were leaning, and they couldn't provide any evidence of that. Indeed, I think what had happened is the compliance officer had heard that some of the boxes had shifted and merely equated that with leaning pallets, which is not always the same. So in this particular case, Americold did a really thorough job of presenting evidence through 5 witnesses.
Hmm.
If I recollect, OSHA only presented 1 witness, and that was the compliance safety officer, and 5 witnesses on Americold's part in a 2-day trial in Houston, Texas.
Hmm.
And so their evidence was, I think, not only more credible, but had a greater clarity to it.
Hmm. And I think the point that we discussed on the previous slide with respect to the employee complaints about working with leaning loads is that the full context of the complaint there was that the complaints weren't about the employees who were complaining were not concerned about the safety aspect of it. They were concerned about the fact that when products were determined to be hazardous, they would have to be unloaded manually, which would take more time during the process.
Okay, so let's talk about the administrative law judge's decisions. This is Judge Patrick. I've known him for many, many years. He's very thoughtful. He's very detail oriented, and he sees, I think, the big picture very clearly. I think he did a good job in understanding this case and going through a 2-day trial and sorting through the evidence and finding its essence. So what the judge found when evaluating the two arguments was that it was maybe arguably clear that there was a potential for a hazard of pallets falling over, and that this was evidenced by the fact that in this case, indeed, a pallet fell over. So when you look at all of the elements, the judge said there's no need to further inquire and doesn't really believe that Americold was contesting that point, that the potential for falling pallets is indeed a hazard, and that the hazard has the capacity for being potentially one that could cause severe injury or fatality. Uh, what the judge said was really more at issue was the idea that there was a feasible means of abatement and that OSHA had clearly articulated what abatement would be satisfactory to eliminate the hazard or mitigate the hazard, and whether or not that was indeed feasible. Uh, I think he also was concerned that when the compliance officer was assessing the evidence for what the deficiency he was alleging by Americold was, that he was in fact demonstrating evidence of a satisfactory compliance program. Let me just give you one example. One of the complaints that the compliance officer alleged was that employees, if they had identified a hazard in the case of leaning product, then they were supposed to notify a supervisor, and the OSHA compliance officer concluded from that the employees had to keep working in order until the supervisor inspected and issued a stop work order. The judge, by contrast, looked at the transcript and found testimonial evidence was clear that the employee did have the right to stop working at the minute or the moment that the worker had identified any hazard or hazardous task or operation. And so the judge noted that it seemed contradictory on the part of the compliance officer that on one hand, the compliance officer was complaining that the instructions to the employees were unclear as to how to handle unsafe product, and on the other had given that the employer had given employees clear instructions that they were required or expected to stop work the moment they spotted a hazard, which the administrative law judge to be sufficiently clear, plenty clear. Those are the kinds of testimonial evidence that the judge found that the compliance officer had attempted to submit into evidence that in some cases were evidence of the employer doing the right thing, not of an alleged violation.
Right. On the abatement point, the judge cited to sort of the standard that goes to an effective abatement program. And an abatement is something that it has to be shown to reduce the hazard posed by to workers. The abatement measures can't only be shown to might be able to be effective, or they can't be used to describe a desired result. And in this particular case, he found that one, the proposed abatements by OSHA were not sufficiently described. So, like we discussed, like the compliance officer and OSHA argued that a protective device should have been used, but they didn't specify what protective device should have been used. And they described situations where, well, essentially saying that the pallet shouldn't have shifted during transit, shouldn't have posed a hazard to workers, but those are not abatement measures that are sufficient for the purposes of proving a citation.
And also, the judge noted that that particular example is one that's not in the employer's control. The product comes under the employer's control when it arrives at the loading dock or unloading dock, and that the shipper is the one who stores the product in the rail car, and that anything can happen while it's in transit, and that the employer, Americold, doesn't even know whether the product was stacked on the floor, which would allow the product to be stacked wall to wall or on pallets until, in some cases, until it arrives.
Yeah.
And so this was entirely out of the employer's control.
Yeah, I think a great example of that also is the reference to the use of dunnage. The investigation found here is that what Americold believed to have contributed to the pallet tipping over and falling was that the dunnage, which were airbags used between the pallets, deflated during transit and then fell over. So when OSHA came and said, "Well, you should have used more dunnage in this situation," Americold and the ALJ pointed out that dunnage was not placed there by Americold, it was placed there by the initial shipper.
Right. And the type of dunnage used is out of Americold's control. Also, there's many types of dunnage that can be used, anything from very sturdy wood planks or crating to pine structures, or it could be cardboard, structural cardboard, or it could be what was used in this case, which is inflatable uh, bags that in this case Americold believed may have collapsed. Those inflatable bags that were used to fill the space to prevent shifting may have collapsed between one pallet and another, and the pallet behind the one that fell may have been leaning, invisible to their inspection until that first row of pallets was removed, and by then it was too late. So their process was sufficient in most cases, and in other cases was out of their control. The other elements of the circumstances were out of their control. Um, the other things that the compliance officer mentioned were things that Americold was indeed doing. Like he said, they should have been training employees, they should have been monitoring for safety, they should have empowered employees to notify the supervisor of any hazardous conditions, and Americold had already done so and had presented evidence that it had already done so.
Right.
Finally, the last category of abatements that the compliance officer proposed was one that was just ambiguous. He didn't have any specificity to it. He said, well, I think that there should have been some kind of device to restrain the product from leaning or tilting over. When asked what kind of device he had in mind, the compliance officer testified, well, some kind of device that would restrain the product. The judge found this to be two things. First of all, vague and lacking the specificity to qualify as an abatement measure. And remember, that's the fourth and critical element. And also, in lacking specificity, it made the proposal incapable of being assessed for feasibility. But also, as you said already, Ben, this was a outcome-derived abatement order. In other words, it would have been the best way to keep the product from tilting is to create a device that keeps the product from tilting. And that is outcome-oriented. It's not a specific measure. It's not a specific step, procedure, device that could be implemented in order to keep the product from tilting. He merely said, keep the product from tilting, which is the outcome to be abated, not the abatement. And the judge caught that and pounced on it and said, that is not fair to employers. You can't do that in your abatement order in an alleged violation under the General Duty Clause. The General Duty Clause expects something more concrete in order to establish that indeed the General Duty Clause has been violated. All right, so that's the administrative law judge's decision. Ben, why don't we talk about lessons learned, what employers can take away from today's episode of the OSHA 3030?
Yeah, I think there's a good bit here we can take away. Starting off with making sure that you as the employer conduct regular hazard assessments at your facility to determine what are the points both.
Something that Americold did at the beginning of every shift and at the arrival of every rail car.
Mhm.
And that really helped them out. And I think employers ought to take a page out of the playbook of Americold and conduct regular hazard assessments, task specific, if indeed every task is a little bit unique. Training, they did plenty of training at the beginning of an employee's onboarding orientation and throughout the employee's career. And there was constant monitoring. Employees were well supervised and monitored for making sure they did their work safely.
Mhm. Also, another good point is making sure that you record employee complaints. We saw it came up in this case. OSHA used an employee complaint history.
Recollect that the employee complaint was, he testified at the 2-day trial. Yeah, I complained that when product had tilted, we had to do this by hand. We had to cut the pallet, shrink wrap, and remove boxes by hand. And when asked, well, what was the complaint about? What were you complaining about that? He said, well, that's just hard work. It's a lot more work. And I would prefer that we do work that can be done by forklift or, yeah, one pallet at a time rather than one box at a time. And so Americold pointed out to the judge, this wasn't a safety complaint. This wasn't a complaint about a hazardous condition. This was a complaint, a regular workday complaint, like, why can't we do this an easier way? And for OSHA to have used that against the employer as if employees had made safety complaints and Americold had turned a deaf ear, the judge rejected that interpretation and said that's not what the complaint was about. So it's important when you record your employees' complaints to incorporate sufficient detail into what the nature of the complaint was so that you can establish later on that it was or was not a complaint related to hazardous conditions, alleged hazardous conditions, safety complaints, etc., which an employee, recollect, has a right to do unretaliated against under Section 11C of the Act, of the Occupational Safety and Health Act. So those complaints in this category for Americold did not qualify as 11C complaints.
Another point is, and I think Manesh, you touched on this earlier, is make sure that supervisors are actively monitoring for violation and documenting safety violations. It's important, even if you have a program in place, the program is written, wonderful. It's good to have that.
And I think one of the things Americold did really well is that they prepared a very detailed explanation to the judge of how they do things the right way.
Mm-hmm.
And the judge walked away with a very clear understanding at the end of a 2-day trial, compared to a lot of cases that are presented before administrative law judges, of what was going on an everyday basis and in that particular moment.
I think it's also important to create a record of when employees are empowered to stop work because of a hazard concern, that that is in fact documented and being able to show that potentially in an OSHA contest later.
Yeah, I think that was great that Americold was able to present that evidence, and every employer should have communicated that to their employees in writing, in training. And this is a debut on the OSHA 3030 after, I think we've been doing this 13 or more years. This is the first time that that bullet item has shown up in what employers should do. So pay note to that. I think that employers ought to communicate, hey, if you see something unsafe, stop work, get out of the hazardous situation, report it, cordon off the area until it gets abated. And that if you've recorded that you've empowered employees to do that, it would inure to your benefit if you're presenting the kind of defense that Americold had to present here.
Right. And eventually, ultimately, I think we can conclude with this is that evaluate defenses based upon the full spectrum of what OSHA needs to prove for a citation. So in this case, we see that the case really failed because OSHA was not able to establish the proposed abatement element. So make sure that the abatements that OSHA puts forth are actually feasible, actually implementable, because sometimes OSHA can get it wrong.
That's right. And sometimes the employer can get it right. And if the employer's gotten it right, they should defy the agency to come up with a better plan, a more specific and better and more effective and feasible means of abatement that the employer was not utilizing. And if OSHA is challenged in the task of doing so, then it may fail to prove its alleged violation, particularly in general duty clause cases. Well, that's today's OSHA 3030. Ben, we will be back, but before then, we've got a couple of sister programs for those of you whose organizations are responsible for compliance with the regulatory schema under TSCA or REACH. You should know that we are programs, the TSCA 3030 and REACH 3030 are coming up soon, June 10th at 10 a.m. Eastern for the REACH 3030 and August 12th at 1 p.m. Eastern for the TSCA 3030. Incredibly valuable programs for really important statutory schema that apply to the chemical manufacturing industry. Now, we'll be back on June 17th at 1 p.m. Eastern, always on a Wednesday, always at 1 p.m. Stay tuned for that program. And when you get the email invitation for that program, please, as we've done for 13 years, we've put this program on providing valuable information complimentary to you. And all we ask, please send your email invitation on to at least 3 others, not only at your organization, but at other organizations, not only to safety and health professionals at those organizations, but also to the in-house counsel, the attorneys responsible for OSHA compliance at your organization and at other organizations, to spread the good word about this program so that we can be doing this hopefully for another 13 or 14 years. That's today's OSHA 3030. I want to thank all of you for attending. I want to thank the staff here at Keller and Heckman for helping put on another great program. Ben Idzik and myself are both very grateful to you all. And we look forward to seeing you again next month. And until then,